one on flow and in delta use. In regard to the first one, I know that EC is measured in several places throughout the delta. It would have been very helpful if we'd had other charts for the same period of time to look at, because the question that comes to my mind is salt increasing at Jersey Point because of in-delta diversions or north of delta diversions, or increased impoundments because it was a drought time? The implication is it's in delta diversions, but I think you need to get the evidence on that. And then also, I guess this is just a comment, and then I will go away. The exporters now are contending that they are facing huge shortages because of delta diversions. Previously, the problem that they had was because water was being let out for fish. I don't think you can have it both ways. And I think that if you want to balance the state's water needs on the backs of delta farmers, then you need to go well beyond our own use and measure everything that comes out of dams, goes into impoundments, and then comes down into this delta, counting every diversion north or south of us, because what we are is the bottom of the toilet. Thank you.
Thank you. Patrick Porgans, Planetary Solutionaries.
Mrs. Chair, members of the board, my name is Patrick Porgans. I'm here to address item 15. Excuse me. Thank you for the opportunity. I wish I could be as enthused as the rest of them. However, there is an apparent data gap in the information, and we are dependent upon the exporters for numbers and their models. You don't have a model. You don't have the information that you need in order to quantify and qualify how much water is being taken by whom, under what circumstances. So we're back to where I was 40 years ago. Forgive me for dating myself.
You got a lot of company behind you. I have to say.
Well, there are a few of them out there, you know. I'm going to remind you once again, this is Bulletin 132-67, excuse me, 63. I'm going to refer you to page 97. Delta pooling concept. Surplus water is the only water they were supposed to take. That was what it says here. That's DWR talking. Now, the way I see it, and of course you have to forgive me because I try not to be opinionated, I deal with the facts. And I know that's difficult for a lot of people. In light of the fact that we don't have many facts, you know, makes it even more difficult for me. But notwithstanding, this fish water thing is a fish story, okay? And all that water under the CVPIA, all that water can be picked up when they get done using it for the fish. So there's real no net loss in water. I've got all that documented. If you need that information, I can provide it to you. Okay, so there's no net loss there. The Department of Water Resources has acquired a number of acres of land in the Delta. For example, Sherman Island. I worked for those people down there. They put them out of business back in the 1991-92 period when the Department of Water Resources illegally diverted 500,000 acre-feet of water worth $29 million. Your predecessors didn't do anything about it. I had 11 legislators over here barking at you. Didn't seem to make a difference. At any rate, what it comes back down to is there's water that's being accrued in the system by the department because those water requirements for those delta lands, 10,000 acres, they don't have that demand as they had it before. You see? So DWR has been increasing the amount of water that's available to the system and the outflow because it's taking land out of production. There's about 100 and some odd thousand acres already out of production. That's owned by the state of California. There's another 168,000 acres that's proposed under this Proposition 1, which they're going to buy with mitigation money that's coming out of the bond fund. Poof, that's mitigation. That's a reimbursable cost. Now, What I'm going to suggest to you today, and forgive me if I'm a planetary solutionary, because I know that a lot of people don't even know what that is. That's someone that's come here to resolve issues. And I've worked with your board in the past, and yeah, you guys have been helpful. And you're at a disadvantage. You're referring to your staff. And they're going to give you whatever it is they got in their head. And I'm saying that there's more in the files than in their heads. And I'm saying to you, you're being shortchanged. Now, if you'd like me to come here like I used to do with the board members when I was up to it, I'd sit down and explain it to you and give you some insight that you may not be getting. And not because I have any vested interest. You understand I don't own any land in the Delta. I own no water, except the fact that it's a public trust resource, But I'm suggesting to you is you need to come up with an alternative way of quantifying and qualifying how much water is in the system and who's taking it. You need to be able to get out there. You have to have an independent source to come out there and say X amount of water is being taken from X point of diversion. You need to be able to do that in a way where you can get that information in real time, not relying on, 3 months later, a year later, or whatever. You need to know what's going on now. And someone needs to take a real good look. I don't need more information from the Department of Water Resources. I need more information about the Department of Water Resources and the Bureau of Reclamation. That's what I need. And I have all that data. And of course, I'm not soliciting, a job because I never came to you for that before. Be hard to work for you. But the point of fact is that we're now, in a real quandary. I asked 40 years ago that you come in and do a water rights adjudication here in the Delta. It never happened. So we're here now responding and reacting to a set of conditions that heretofore would have been resolved in the event we took the action that I had suggested way back when. Okay. So lastly, I'm done with that subject. Okay. So I wanted to say that I was remiss not getting here earlier today, but I do work late into the early hours of the morning. On the TUCP, I think that from what I heard, and I want to compliment you, it appears that you want to put a little bit of teeth into your bark, requesting DWR to come up with information that you want, which heretofore they may not have provided. That's good. DWR is only an agency that operates the State Water Project. They don't own the water. They're in business of a purveyor of water. 85% of their money comes from the contractors. It's time that the Department of Water Resources comes under the microscope, okay? And I believe that if this board takes an action to do that, this state will be a whole lot better off as we go into the future. Thank you.
Thank you.
You're welcome.
Valerie Kincaid, San Joaquin Tributaries Association. I've been holding Tim's card. He didn't come back, so you clean up for him.
You can probably dispose of it. Good afternoon, Valerie Kincaid, San Joaquin Tributaries Authority. The authority supports, I think, the one common theme that I've heard here today, which is increased certainty. I know Mr. Rubin and Ms. Spalletta both spoke to that in different ways. And certainly that's the emphasis and the goal of the tributaries, if anything in this process, is to increase this certainty with which the system is allocated. And we don't think that the State Water Board can truly allocate water resources with the lack of information currently existing in the Delta. We brought that up in our Phase 1 comments, and I'm sure we will continue to do that, that if we don't know where the water regulatorily required to remain in stream goes, it's going to be very difficult for us to support that kind of a regulatory action. And I want to talk a little bit just about process, and this is
Please.
Really not that we have a huge dog in this fight, but just more observations about what I've seen and kind of heard today. From my perspective, I think there's two ways you can create certainty. One is getting folks to have contracts in the Delta, and the second is to go through and validate water rights. So I think your process has to really depend on which end goal you want. If you want contracts, perhaps facilitation of contracts between the projects and the Delta folks. I know that that's a can of worms all into itself, but perhaps going down that route is something that we haven't talked about a lot today, and people haven't really unburied and looked at. So I don't know how possible that is, and I don't know if the State Water Board would want to get into it, but certainly that's one avenue. The second is really where the focus has been today, and that is on this concept of validating rights. The San Joaquin Tributaries Authority supports collecting more information, and I think that's a good first step. How you do it should be taken fairly seriously, and
Right.
I would suggest, as Mr. Rubin suggested, using existing powers of the State Water Board, perhaps even looking at the Statement of Diversion and Use and asking for more information or changing that existing document to solicit the more specific information that the State Water Board wants. There is a caveat or a warning or perhaps a downside of this gathering of information, and that's that I think we should all be very clear about the limited value it will have in next year's curtailment, if necessary, process. If we have to curtail next year, and we do this information collection, which again, the San Joaquin Tribs supports, but if you're going to ask legal water users upstream to curtail based on statements of diversion and use and assertions of water right claims rather than valid water rights, you're going to run into a lot of the same problems we ran into this year. So I do think it's a good first step. I think we should head down that road. It'll be interesting to see when that process becomes an adjudication and triggers an evidentiary hearing. It sounds like a lot of folks have a different trigger point for that today, we've heard. But just to make sure that everyone knows that collecting information, at least from my perspective, will not allow the State Water Board to become a really effective curtailment machine next year if
Right.
necessary.
That's probably true.
Because a valid legal water right can't be curtailed based on a statement of diversion and use and a claim to use water. So,
Thank you.
thank you.
That's
Thanks.
helpful. Thank you all for that. No, thanks. I don't know what I expected with this, but as I started, I like the idea of workshops to throw the questions out. I like the idea of you all hearing what each other has to say versus us seriatim talking to you either in the field or in conference rooms, because part of our challenge is to figure out how to sort it out. And I do think that it illuminates some issues. It may seem less focused for some people who are kind of laser beamed, but I think in the long run it will allow us to propose more thoughtful things. And I've heard a lot of things here, and I don't actually have a statement on what we ought to do. I just have a thought. So we've heard a lot of things from people, both as between the need for an evidentiary hearing, but if you're going to have a hearing, you have to have your hearing about what, in what context, why are you teeing up an evidentiary hearing? So we'd have to think about that, different ways of dealing with legal issues. We are supposed to decide a lot of legal issues, and courts also refer things to us in the first instance. So I'm open to thinking about declaratory relief if it goes faster, but I also think we're here for a reason, which is to try and resolve issues of law and of fact. But people obviously have their appeal on, I guess, on the law and on the fact. So there's a whole passel of things to deal with that. I think in terms of the draft order itself, I think, correct me if I'm wrong, staff put that out as a draft as a discussion tool, not because you're proposing that that's what we do. Because I don't think you're terribly disappointed when I say that 5 days to do anything doesn't really make sense, but that it helped surface issues for people to raise, as well as the proposed other set of information that folks suggested.
It was proposed for a discussion and whether the information that we're requesting was sufficient.
And the 5 days is in the emergency regulation as opposed to in the order itself. So
we could do it however we wanted
The
if we
board-
decided we wanted to do it or some other it.
yes, absolutely. The board would have discretion not to require the information in 5 days, but just to be clear, the 5-day return on the information request has its origin in the emergency reg as opposed to the order.
Right, and it doesn't say we have to do it, though, in 5 days. It allows us to do it in 5 days, or were we unclear on that?
It says that if people are requested to provide this information, they shall provide it within
Oh,
5
okay.
days, but I don't think that that would bind the board to allow people more time
Right.
if they so chose.
And
you
that
would
was
put
geared
that
more
on
towards a complaint.
you would put that on the face of the order if you were to do that.
So then there are questions about what questions should we answer? What's the geographic scope? What are we trying to do? Are we planning towards curtailments in 2015? Or are we figuring out how to make the water rights system more intelligible? Or are we trying to figure out what are the diversions so we can manage the system better? I mean, there are a bunch of different things that have come up in terms of the interests of the people who have come before us. I mean, I, for one, would like to reread a bunch of the comments, although I appreciate people's brevity, be able to have some more conversations, but also have staff really step back and think about what are our objectives and what are our options under certain objectives, and to hazard making some sort of a proposal to us on what you think would help us administer the water rights system and solve some of these problems. But I need it sorted out by problems and solutions. I don't know, if happy to put a finer point on it, but I really want to sleep, and really I tried very hard today, just sit back and listen to what people were trying to say and just sort of take it in. It was good to have everybody in the room. If I could make everybody go have dinner with each other and see if they could sort it out, I would. I don't have really the Werner Erhard kind of power or instinct to force people into a room till they could come up with something. So I think we may have to suggest some way of moving forward, both in terms of our what may happen in another dry year, but also our ability to administer the water rights system with our hands tied behind our backs, which is what we have right now. Sure.
I thought Mr. Rubin's comments were very interesting about suggesting that we consider using existing authorities in the event that we move forward asking this additional information. So just hoping that staff could comment on that. He outlined, you know, his view of our existing authorities. Is there anything that you would have to add or comment on if that's the route we chose to go?
Part of the reason why the staff, I think, at first teed this up around the Emergency Regulation Authority in 1058.5 is it provides greater certainty about the expedited monitoring and reporting requirements that are available under the Emergency Drought Regulation Authority, whereas there are open questions about in conducting an investigation under Water Code Section 183 and some of the other related sections referred to by Mr. Rubin, just how expedited and efficiently the board can obtain that information and the type of information the board can get under 183 without going through an evidentiary hearing in the first instance. I do want to be clear, there has been a lot of conversation about evidentiary hearing and whether or not the ultimate issues, not perhaps whether or not a reporting requirement gets issued, but the ultimate issue of how to resolve these complicated issues in the Delta, I think all along staff have assumed they would culminate in some form of evidentiary hearing, and that was part of the exercise that folks were going through here today, was to try to figure out what's the best way to do that, to provide certainty both for the in-Delta folks who keep hearing arguments raised questioning the validity of their water rights, as well as the projects and other diverters who keep pointing to some of the Delta diversions as a source of conflict for them and as a challenge to their stored water releases.
Right, it's just an issue of when it gets triggered or whether or when we decide to trigger it, yeah. And then the other question that I had was on timing. So whether it's 5 days, 10 days, 20 days, or a different route altogether with existing authorities, do you have some sense on the amount of time that it would take you all to receive that information and compile it in such a way that you could present it to us for future decision making?
I'll let John and Yvonne speak to that more so, but one threshold issue that I think your question raises is what type of information we'd be asking for, what the scope of that is.
Yeah.
The draft order that was attached to the workshop notice, as was noted already, doesn't ask for the specifics of patent date or anything like that. It just asks for the type of right, because what the draft order was intending to get at was more of a discrete question under the emergency regulation of putting aside temporarily all of the other questions that would have to be answered for that. But that information would be helpful in deciding potentially whether stored water was being taken. And for that, it doesn't really make much of a difference whether an in-delta right is claiming 1800 or 1912, because
Or is riparian.
or is riparian. And as to which of those types of rights or what date, it doesn't make a difference as relative to stored water. So we didn't have to answer those questions. If we were answering a different question, like curtailment in a future year as between riparians and pre-1914 diverters, then we would want to know those things. But that wasn't identified in the draft order because it was looking at a more discrete question. There are lots of other types of information that have been raised that would be helpful for that too, but I just wanted to point that out before maybe John or Yvonne could talk about how long it would take to go through that information, because it depends on, in large part, on the scope. If we were looking at a scope of information that included the exact diversion date or initiation of diversion date for all of the Delta diverters, it's been mentioned, take a lot more time to get that, although it's certainly possible and we ask for it in proceedings. But it would take us longer to deal with that as well, as there are going to be questions about upstream, downstream, how the dates relate to each other in terms of the watershed. Some of the commenters talked about what is the watershed. So it would take longer.
Yeah, just to speak to that a little bit, and then I'll let John maybe address the specific resource question. The draft order that was attached was for conversation. It was tailored to be responsive to what the emergency regs allowed us to ask for in a quick turnaround time period. And with that in mind, we limited our request to what we thought was a little more reasonable for response within that quick turnaround time period, with an eye towards addressing the immediate emergency needs and immediate emergency situation proposed by the drought. It was not tailored or intended to be a long-term adjudication resolution of water rights within the whole delta, exploration of the basis of all those rights. And accordingly, it does not currently include any language about requiring the submission of patent dates and specific documentation about the date being claimed, of the priority date being claimed. So with that in mind, before we could answer a resource question, we turn back to the question that a lot of the speakers you heard today raise was, what is the goal? What is the point and the intent of this information? If the intent behind the information is merely to better quantify the demand in the Delta going forward, then the information that we requested, we did so in a surgical focused way so that we could process and use that information quickly, and that staff could take that information and plug it into a lot of the models and the considerations that we currently use. If we are going to expand the scope and look to validating rights and the underlying basis for those rights and do more of a adjudication of those rights type of thing, then John, can speak to the staff resources. I do appreciate Mr. Rubin's comment, and I will say that it would be a great way to use most of the attorneys in the Office of Enforcement.
That's what they're there for, right?
So if we want to use them for depositions and subpoenas, that would be a way to go.
But let me get seriously to a question of this. So if people have questioned the question in terms of what the question ought to be.
Yes.
So one approach that staff had recommended earlier during the curtailment process was that we do it in a way that just protected stored water. That would be the way we would do it, because you'd be dealing with protecting stored water as it came down. That ended up, we talked about it at a workshop where there were a number of options. It wasn't clear to a lot of people how all of that would work, and so we didn't move forward with a number of things that weren't clear. How can you, unless I'm mishearing what people are saying, how could we do that without resolving the conflicting claims about who's able to divert what in the delta? Could we have done what you all were proposing that we do if that theory still remains there? Right, some think it's the law, some don't. That's part of the legal question people are raising, that once it's commingled, folks in the delta claim they can take it.
That raises a lot of the supply issues that we listed on the workshop for discussion, like quantifying what the supply is going in. But as far as the scope of the emergency regulation that we proposed earlier, I'm going to turn to David a little bit.
I mean, you don't have to go through the same argument. I'm just trying to figure out there's
was-
a conflict in law. Some people are just assuming, they don't talk about the law, but they assume that looking at the chart, since I'll just pick on the South Delta, that because there's less water, they're taking more water than is actually coming down the San Joaquin, that they must be taking somebody else's water. So there's a legal question embedded in there. It's an assumption on their case, but there's a legal question. And as soon as we tried to do anything about that, we would have to state what our legal assumption is, and then it would be challenged. So you can never get away from it in the course of whatever proceeding we have. And my interest is just sort of trying to figure out both how to rationalize our system as best we can, maybe like a turtle, or a tortoise moving forward slowly, but it's better than the stasis we've been in for a long time. And trying to understand if we were going to do something that might have any impact next year, how we would do that. Without getting to the legal question. I don't say we get away from the legal question.
I don't think you would get away from the legal question. Certainly, any action we took would be, I would expect to be challenged, like the other emergency regulations that the board has adopted. The options that turned into a workshop and didn't go forward, I think Tom had mentioned them earlier today about applying Term 91 to everybody. You certainly have questions about whether you would get challenges on that. And so the legal issues would come up. So I don't think there is a way to avoid those legal issues. Potentially, you could parse some of the legal issues and address them one at a time. You would not get to the end game that I think everybody seems to be interested in getting to, which is something akin to an adjudication in total. But if you answered one or two of the questions by, in essence, applying Term 91 more broadly, then potentially the legal challenge to that would take those off of the table by having them had been addressed by the board and then on a petition for writ of mandate, so that in the next proceeding those would have been answered.
Right.
It's
and
not
others
fast.
have argued that you do it in the context of an enforcement proceeding.
It could be done that way. I prosecuted the Woods Irrigation CDO hearing, so I won't talk about that, but that was one example of...
See, it's good. You're coming back to where you started.
I haven't moved very far.
Yeah.
The board addressed several Delta-related issues about water rights in that without addressing everyone's water right issues. So that's sort of what I was talking about. If the board were to do something like a Term 91 applied to more diverters, is it would address some of the issues as opposed to all of the issues. I can't say whether that would be a better approach or not. It depends, again, on what the goals are. In part, what the draft order, not even a draft order, but the draft of a draft order that was provided with the notice for purposes of discussion only, was focused on using the emergency regulatory authority. If the board were interested in doing what many of the commenters are talking about and addressing everything in the Delta, using emergency regulatory authority might not be the best way to do that, because yes, there's an emergency, and yes, the Delta is a major linchpin of the impacts of that emergency on diverters in different parts of the state, but that doesn't mean that the process to address it would be an emergency process. So we proposed using an emergency process to address an emergency issue. All the other issues may be better suited for non-emergency processes.
But
And
would,
Sorry, I just want to speak to the use of the emergency authority versus the use of the state board's underlying authority to investigate stream systems. Again, the proposed or the attached or the order that was provided for conversation purposes tailored to the authority granted in the emergency regulations to gather information on demand quickly would be immediately enforceable as a violation of the emergency regulations if somebody failed to report. So it was addressing a very limited situation related to the emergency. Two, it would have been required quick compliance, and it would be quickly enforceable. Relying on the our underlying authority to investigate, as Mr. Rubin pointed out, is enforceable potentially through subpoenas and declarations, depositions. But the enforceability of those the tool is to bring up a contempt charge and go to court, be represented by the Attorney General's office, and
only?
in a court of law to try to enforce those types of investigatory requests. And they are specific to a certain party, and getting broad compliance becomes a little more difficult, I think. Again, different vehicles, different purposes, different goals. Just wanted to point out some of those differences.
Were we to get the information, and I'm not suggesting we do this, but
Right.
let's assume we issued the draft request for information and we got all the information we asked for in 5 days, what could we do with it?
We could then take that information and use it to bring a lot of the data that we relied on this year was, as we discussed, based on triennial reporting. The information requested asks for both this year's diversions, and we've heard a lot of comments about along the lines of you can't rely on demand data from 3 years ago because it wasn't a dry year. You didn't have the same issues that you have this year. There's been response in fallowing fields, and it's a different ballgame. That is not reliable. And in addition to getting the more current data, it would also provide, we asked for projected use, because then there's a question of, okay, going forward, it's a dry year. If everyone is discussing the fact that it's probably still going to be a dry year going forward, how have the water users in the Delta responded to that? Have they fallowed fields? Is their demand changed? What's their projected demand? Where I think we've all admitted that they're in a better position to understand it than we are, and the information requested in that draft order it demonstrates an attempt to get that better understanding, or to at least
And then
have them tell us
what
what
would
they
we do
think
with
they're
it?
going to be doing going
But
forward.
then what would we do with it in the emergency context?
Use it for future curtailment decisions, possibly, or future regulatory decisions on how to respond to the drought, planning, the strategic planning that you discussed, the scenario plans that you discussed going forward.
I think what we would also use that information for is to look at the permanent lifting of curtailments if the need be. If our demand analysis is higher, then that would shift the demand for other water rights in these watersheds, and perhaps allow permanent lifting of some of the post-1914 senior right curtailments earlier than what we are relying data on right now, because we would have diversion data under this order through December, and that's the limitation of the emergency reg, I believe. So we were looking at that as getting it for also decisions on lifting curtailments as well.
Right, but that's something you might need beyond the Delta as well in order to make those decisions.
Correct. But
Okay, so there's a scope question too.
Not exactly. I mean, there's a scope question in theory, but in practice, we've got the complaint, as it was styled, or the information under the emergency regulation that allowed us to ask for it under the emergency regulation in the Delta only. So there's certainly the same issue would apply in other areas, But under the emergency regulation, until the board gets either a complaint or information suggesting that stored water is being taken, we don't have that emergency regulatory authority to ask for that same information. So we're asking for it in the Delta, or, you know, the draft was proposed discussing whether we would ask for it in the Delta, because that's what the emergency regulation that the board adopted allows for us to ask under that authority.
Allows us to ask based on a request.
Allows us to ask for, with the teeth that are in the emergency regulation, for for not providing the information. So we could ask for information anywhere else we need it, but we wouldn't have the emergency authority that we do under the emergency regulation to make sure that people give it to us in the time that we want it in order to be able to use it. So this would still be very useful for, like John said, curtailments, and I imagine it would be useful to the projects as well for their modeling, but we would use it for making sure that the curtailments were as tailored as appropriate, or as tailored as possible based on all the information we have of actual diversions. That was a criticism that had been levied before, is that we didn't have enough information to do curtailments on supply and demand.
But it was beyond the Delta that
It
we
was
didn't have enough information.
It was statewide, I think, that people
Right.
were suggesting we didn't have enough information.
Right.
We're targeting the Delta because we have the authority right now to ask for the information under the emergency reg, and because it's a priority area almost all the time. I think that if we got a complaint in another priority area, we would do the same thing there.
That was the point I was trying to get to.
Yeah, it's important to keep in context that as far as the post-1914 appropriators, they have already been required to ones that have been curtailed have been required to submit their curtailment certification with some of the information about past diversion and use. And so we have that population that has already, under the emergency regulations, been required to report to us certain information. And the emergency reg has this provision in it that is cited in the discussion draft, 879, for reporting to address when the board determined that they were not going to seek authority. The riparians and pre-1914s were kind of carved out for the statewide curtailment. They
I
said
remember.
in the light of complaints that we could seek this additional information. And so far to date, this is the watershed where we've received an allocation of the taking of stored water.
Great. Go ahead. I'm going to bring this to a close, so if you have closing questions.
Since this is the last meeting of the board when our current water master is in place,
Goodness.
and he has sat through this entire discussion, it seems to me appropriate to hear from him just briefly, very briefly, as to, what your take is on what you've just heard. Sorry. And thank you.
And here I thought I
should have
was
had a
going to
cake
be
or
able to
something.
quietly slink into retirement. Be careful what you asked for. I did take some notes while listening to all the comments, and I guess not surprisingly, the advocates took positions, the Delta interest basically saying, hey, we want business as usual, just leave us be. And you heard the exporters saying, basically, let's consider undoing diversion practices that have been undergoing for over 100 years. So I think it's incumbent upon the board to try to figure out what a reasonable response is, and I think it's probably somewhere in the middle of those two extremes. Regarding informational orders or gathering information, I think you can break it into the two different types of requests. Some people were asking for the informational orders regarding the amount of water used. That was the focus of the project's request, needing that information for planning purposes. My response, I guess, an informational order to some 1,500 small farmers in the Delta in a very short amount of time to provide information. I'm not sure how much that would move the ball forward. I'm really intrigued by this idea of the remote satellite sensing data. I've gone to some classes on that. I've talked to people about it. I think if the board could facilitate getting the Delta agencies together with the project people and trying to explore this idea of using that type of 21st century tool to get us more real-time information on water use, I think would be a good idea. Regarding informational orders on water rights, I have a lot of respect for John Rubin, but I disagree with what he's recommending. He's basically saying that he wants to kick off the process regarding water right claims by firing letters off to all the diverters in the Delta, asking them to confirm their water rights. I think there is somewhat of a burden of proof issue here. I think if you really want to explore those water right claims, I think the two avenues to go are either, on a micro level, have complaints filed if there's specific information that the people have as to the illegality or alleged illegality of the water right, then make that case, and then it could proceed. Conversely, is the idea of the declaratory relief, which I think has has some merit to it, and I think it probably could be explored as a way to, get some certainty. There's some very heavyweight issues here about, the Delta pool and the natural flow and the stored water and the commingled rights, all the things you heard about today, and they've been talked about for, decades. And to resolve those has some appeal to it. Not to let the Delta people, off scot-free. I think there are some things that could possibly be considered that were not raised very much in this hearing. I think the idea of the board trying to facilitate getting the South and Central Delta Agency together with the projects to talk about possible consideration of contracts, consistent with the Delta Protection Act regarding supply and quality would be, a good idea. I don't know that the same facts apply in the North Delta, but there is a contract there. It provides a great deal of certainty, and I think at least an effort might be worthwhile to try to resurrect those discussions, which I know they had some way back in the peripheral canal era. And a couple of other things that could be done, I guess, is a little bit farther out there, but one of the very first reports that I did as Delta Water Master, which got me in a bit of hot water, was talking about the reasonable use doctrine and agricultural use. The Delta, in some respects, has been irrigating pretty much, as usual, at least compared to other areas of the state, and perhaps, asking them to come up with some sort of conservation or, efficiency practices to conserve at least some amount of water. When you hear about a lot of people, having zero allocations, even though it's contractual rights, not water rights, 0 to 75%. Maybe the Delta people should be you should consider asking them doing something to see what they can do on the efficiency and conservation, and to take some water out of the equation. The other thing is, as your Bay Delta plan proceeds, there's this whole issue of responsibility for meeting the water quality standards. Right now, that responsibility is placed entirely on the projects, and I know your staff is looking at that again and about possibly reconsidering what was called in the old days Phase 8 of the earlier proceedings, and possibly looking at reallocations that share that responsibility to people in the larger Delta watershed, including Delta interests, and that way could possibly share the responsibility for some of those. So those are some thoughts. And again, while I'm up here, I want to thank the board for appointing me, especially Tam and Fran that were on the board. I've had a very interesting 4 years, so thank you.
Yeah, thank you, Craig, very much. You've done a lot of great work. We may have to have you back for a more formal goodbye with cake or something. Fanfare. All right, are there other thoughts and comments? I've sort of said, I want staff to think about this, but before, I don't have a set. I know for some of you, you have a strict timeline or whatever. I think we need to do some strategic internal thinking, and then I'm going to want to see some options that lay this out. It's been a bit of a mush, and I think our objective is not just to react, but to lead. And that's what I actually want, is some options to lead us out of the morass. But it's got to be fair. So I'm looking to you, Mr. Lawfer, to help lead that. All right, thank you all very much for your time. We'll get back to you as soon as we are able. This meeting is adjourned.